Please the court, Rebecca Creed from the Jacksonville firm of Creed and Gowdy, together with Matt Stoll, we represent the plaintiff, Appellant Daniel Gowdy. I'd like to reserve 3 minutes for rebuttal. The plaintiff asked for a reversal of the judgment on the jury's verdict and remand for a new trial. In this case, the trial judge's evidentiary rulings denied the plaintiff a fair trial. In an abrupt and unanticipated reversal of the pretrial rulings in limine, the trial court excluded the relevant admissible opinion testimony of the plaintiff's only standard of care expert, Dr. Schifrin. Dr. Schifrin
the doctor did give some testimony on opinion testimony, as I recall directly.
He did give some opinion testimony, but he was the only standard of care expert, and he was the only expert who could correlate the breaches in Dr. Garcia's care, the negligent misuse of the vacuum, to the ischemic injury that ultimately was found to have caused stroke.
I have a 3-part question. Tell me what motion in limine the judge said he would allow. Tell me what he did not allow. And tell me how that was preserved for us to review.
Yes, the first is it was a motion in limine by the defense to exclude Dr. Schifrin's opinions as to causation because he was not a perinatal brain expert. And the trial judge ruled that he could still give opinions that correlated the breaches in the standard of care to the ischemic injury because he was an OBGYN, he was an expert, he was well recognized and had studied and researched the causes between vacuum extractors and the kinds of injury that the plaintiff suffered here. So before trial, the judge denied the defense's motion in limine to exclude that evidence. At trial, he reversed course and essentially granted the defense's, sustained the defense's objections to any opinion on causation as to whether those conditions during labor and delivery were enough to cause the ischemic injury that then the plaintiff's causation experts found had resulted. There's a difference between ischemia and ischemic injury. And what Dr. Schifrin was allowed to testify to was that the misuse of the vacuum created ischemia, which can be a temporary interruption in blood flow. And every baby can have ischemia during labor and delivery, but not every baby has an ischemic injury that results in neurological harm. And what he was excluded from testifying to at trial was that this misuse of the vacuum was enough to cause a likelihood of neurological injury, which was the ischemic injury. And then those causation experts said, yes, in fact, the cause of the stroke was a mechanical injury, so that there was never that link between Dr. Garcia's negligence and the injury that caused harm here.
I guess I'm confused at the distinction that you're drawing between a standard of care witness and the testimony he gave. It sounded like causation testimony. I mean, standard of care, in my way of thinking, is this is what you're supposed to do, and then you stop. And a causation is because you didn't do that, this happened. And it sounds to me like that Dr. Schifrin was right there in the middle.
There definitely is some overlap. But that was testimony that he was qualified to give. He did concede he's not a perinatal brain expert, he's not a neurologist, and that he wasn't there to testify to the specific cause of the stroke. What he was there to testify to was that the negligence, the misuse of the vacuum, created conditions that could cause neurological harm, that there was enough ischemia shown during this labor and delivery that could cause an ischemic injury. And then it became the causation expert's role to say that the ultimate stroke, which was the ultimate injury, was caused by this ischemic injury, these ischemic events that had occurred before his delivery. I would also like to add to your point that aside from the reversal of the motion in limine, the ruling in limine, this error was properly preserved because the plaintiff made a proffer of what Dr. Schifrin's testimony would be as to the reasonable circumstances and conditions that an OBGYN would have known and appreciated, and he made a proffer that Dr. Garcia, in fact, put this baby in harm's way of a neurological injury in his proffer, and that testimony was still excluded, even though Dr. Shiffrin was well qualified to render an opinion that links these breaches in the standard of care to the likelihood of neurological harm.
Was this motion limited or at the time?
That was made at the time of trial. At the motion limited, we had prevailed. The trial court had.
Okay,
I'm sorry.
My question may not have been clear. At the time that the judge elected, the trial judge elected to exclude the testimony, was there preservation of what you perceive to be error by your client at that time?
Yes, there was. Yes, sir. Where this is really...
Let me help me real quick again. Dr. Shiffrin, as a standard of care expert, was there to tell the jury that Dr. Garcia was negligent by using the vacuum the way he did
under
for
these
the number of times.
circumstances.
Okay. But then what link was necessary after that to get to the causation? I mean, I guess I'm missing the link because you had a number of causation experts come in that said, you know, if that vacuum was done the way it was,
Okay.
Where did I miss it?
Well, the causation experts did not give any opinion as to the standard of care. They gave no opinion as to whether the vacuum extractor was misused or was used properly. So that's not present in their testimony. What they testified to was this baby suffered a stroke or cerebral infarct, and that stroke was caused by some kind of mechanical cause as opposed to a blood clot being thrown from the placenta to the baby's brain. So that is what their testimony was limited to. You then needed to show, as the plaintiff, that it was something that Dr. Garcia did or didn't do, that his negligent misuse of the vacuum extractor under these circumstances not only created ischemia, which again is a temporary interruption in blood flow, but that under the circumstances that then existed, that ischemia was enough during labor and delivery to result in an ischemic brain injury. And that's...
How is that not pure causation rather than some sort of standard of care? And didn't he say, I'm not qualified to give the opinion you're asking you wanted to give?
Okay. He conceded that he was not there to testify that this baby suffered a stroke, a cerebral infarct. That was the role of the other experts. What he testified he was trained to do and was equipped to do was to testify to this relationship between the standard of care. The misuse of the vacuum was enough to create these obstetrical conditions in which neurological harm can occur. And that is what he testified to, that he's researched and published on these questions of use or misuse of the vacuum is enough to cause cerebral infarct. It's also, where it plays in is the theme of the defendant's case. The defense has always been that vacuums don't cause strokes. That's their theme. And it's not that vacuums sometimes could cause strokes. It's not whether the OBGYN misused or appropriately used the vacuum. It's simply that even if an OBGYN had misused the vacuum, it may cause some other kinds of injuries, but it never would cause this kind of injury. And it's that Dr. Shiffrin's testimony is directly relevant to, because it goes to show that, yes, he has researched these issues, that vacuums do cause these kinds of injuries, and that in this case, the misuse of the vacuum under the circumstances that then existed, the neurological potential for neurological harm that then existed during the baby's labor and delivery was enough to cause ischemic injury, which is the same injury that ultimately was found to have caused the stroke. And so what Dr. Shiffrin is not allowed to testify to are examples in which a reasonably careful OBGYN would have known and appreciated those circumstances and would have taken action to avoid that risk to the baby. And so that's not strictly a causation opinion. That's an opinion related to the standard of care and how that standard of care, the negligence of this physician under these circumstances, establishes the likelihood of harm, the foreseeable harm that can then occur, and which other experts, causation experts, testified did occur in this case. And instead of just...
If I'm looking at a portion of the record pulled out that he did testify that the evidence of ischemia on the tracings was the result of the misuse of the vacuum extractor.
Again, ischemia.
Is that not the link that you
No, respectfully it's not, because ischemia is different from ischemic injury. You can have ischemia that a baby can recover from. And ischemia, a baby can have contractions and experience contractions and have ischemia, a temporary reduction in the blood flow. But this ischemia was enough to cause an ischemic injury, which the causation experts found was the ultimate cause of the stroke. There was enough of an interruption and reduction in blood flow because of the continued misuse and negligent use of the vacuum to lead to circumstances that create this potential for neurological harm, permanent harm, not just temporary. And where it also plays into the defense theme is that while the trial court excluded Dr. Schifrin's opinion testimony, it improperly allowed the defense to bolster the expert opinions in its case.
And this has been addressed in the motion limiting also?
Yes, that was addressed in a motion limiting, especially as to Dr. Thorpe, the defense standard of care expert, who was prohibited in limine from testifying that as to the lack of medical literature to show that vacuums cause strokes. So what we're left with is the defense was allowed to bolster the opinions of its experts with pointing to the supposed lack of medical literature to show that vacuums cause strokes. In addition to which, then the defense was able to characterize the plaintiff's theory as junk science because there was never anything to link Dr. Garcia's negligence to the ultimate injury in this case. The jury never heard that a reasonably careful OB-GYN would have
On your second point, your argument, I guess, is that while it may have been proper for them to ask your experts whether there's anything to support this theory, it was improper for them to bring out in their direct case that there was nothing to support this.
Correct. Under the evidentiary rules, it's improper to use hearsay to bolster an expert's opinion on direct. And in addition to this whole notion that our theory is junk science, the defense was then allowed to bring in an NIH
Your
study.
whole theory was junk science?
That's the defense's argument, is that our theory was a cockamamie theory that nobody never heard of. Everyone knows that vacuums could never cause this kind of ischemic stroke. And then the defense was allowed to bring in a chart showing a 99.9% statistical correlation from the National Institutes of Health that their defense experts...
provided during discovery?
No, it had not, Your Honor.
Was it objected to?
It was objected to on the grounds that it was hearsay and improper bolstering. Yes.
But not on the basis of discovery?
Not on the basis of the discovery, but definitely as to the improper bolstering and the hearsay. And that particular expert, who was Dr. Schwartz, then relied on that statistical correlation and what he described as the largest birth study ever conducted to support his opinion that the cause of the stroke was not just an ischemic injury from any vacuum extractor, which everybody under their theory knows doesn't cause strokes, but it was a placental abnormality that he testified that this baby had.
I don't want to get too far afield, but did you depose that witness?
Yes, sir, we have.
Had that study been referenced during the deposition?
It had been, it's in our, yes, it had been referenced, but he had said he really doesn't consider any literature to be authoritative, and that, there was a study, but everybody knows about it, so I probably won't even talk about that. And then at trial, it was on a chart shown to the jury, and he was allowed to testify at length as to the statistical correlation over our objection that that was improper bolstering on direct in the use of hearsay evidence. I would like to
let you, we'll give you an extra minute in rebuttal since we distracted you a bit.
Thank you.
Sit down, and we'll add a minute to the other side.
Good morning. May it please the Court, I'm Shelley Leineke on behalf of Dr. Garcia and his professional association. We believe the trial court properly ruled during the course of the trial. There was no abuse of discretion. The evidentiary rulings that he made were appropriate and correct, and the jury verdict was based on substantial, competent evidence and should be affirmed. As to Dr. Schifrin, he was properly limited to his standard of care opinions. As we pointed out in our brief, he very carefully and very specifically said he is not able to say what caused the injury. He acknowledged that this is not my role to say what the injury was. I'm looking at pages 9 to 11 of our brief where we quote from his testimony. He says it's not my role. He absolutely agrees it is not his role to tell the jury that the baby's ultimate outcome is related to an injury suffered around the birth. He acknowledges he is not an expert in strokes, pediatric neurology, middle cerebral infarcts, diagnosis of this kind of injury, and it is absolutely true, he says, that the cause of Daniel's injury is outside his area of expertise.
I think what the appellant's argument is that he was not able to fully testify to what the standard of care is and what the breach was, if I understand the argument, and that is that in addition, that in essence what they wanted this expert to testify to and what he was not permitted to testify to is that under the circumstances that were occurring at the time during the delivery, and knowing that when those circumstances exist, use of the vacuum extractor can cause ischemic brain injury. In light of all of those circumstances, Dr. Garcia's decision to move forward with using the vacuum extractor was a breach of the standard of care. That, I believe, is the argument.
I believe he fully expressed all of his standard of care opinions. When you use a vacuum extractor, when you don't, how long you should use it, what happens if you don't use it right, why you have all of these things. He said, he testified that there was no indication for a vacuum extractor here, that it can be dangerous, that it can cause this kind of brain injury, that there was no brain injury at all before this baby was in the labor and delivery room, and there was no injury before Dr. Garcia was actually there. These are all standard, they're really causation opinions, but he was listed solely as a standard of care expert, and he testified concerning the standard of care. DUS had several causation experts. They had their pediatric neurologist, they had their pediatric radiologist, they had a perinatologist, they had a variety of experts there to testify as to the standard of the causation point. I've never heard of apparently we're trying to now make a bridge expert that is the bridge somewhere between standard of care over here and the causation over here. But I believe that the two types of experts that we recognize, that being your standard of care expert who says these things were wrong, this is how you're supposed to do it, this didn't meet the standard of care, this did not meet the standard of good medical practice, and you have your causation experts that say we saw certain physical conditions at the time, and these physical conditions were purely and exclusively caused by the doctor's actions. That's your causation. Those were fully expressed over and over and over again by the plaintiff's expert. The jury just simply did not believe them.
Procedurally, does it matter that the judge ruled one way in the motion to limit and another way at the time of trial? Courts do that all the time. Courts, and that's why when a motion in limine, you've got your pretrial ruling where it's granted. If the other side tries to go into something, you have to again raise your motion in limine at the time of trial. It happens all the time. A court makes one ruling, or rather the court makes a ruling denying the motion in limine, and then you have to preserve that error again. And sometimes the court changes its mind. That happens all the time. When the court predicts in advance what he is going to allow or she is going to allow as the evidence at trial, that's a dynamic thing. Things happen in trial. Evidence comes out. The court gets more fully advised of what the issues and the facts are. And I don't think any practitioner can absolutely categorically rely on a pretrial motion in limine and say, well, I don't have to worry about that ever again. Trials are living, breathing animals that have different aspects to them. So we believe that Dr. Schifrin was properly limited to his pretrial opinions, that the plaintiffs were not in any way limited in terms of what they were allowed to show as their claim. Their experts
said by differential diagnosis they were coming up with this theory. The jury agreed with our experts that however the vacuum is attached, any damage is going to be superficial to the skull, that the skull bone is going to protect the interior of the brain, and that this injury that began deep in the brain was not reasonably caused by the use of the vacuum extractor. The vacuum extractor pops off if you're pulling it too tightly. This was the kind of an injury that was way in the base of the brain. It was not superficial. There was a dispute as to whether there was even sufficient blood, this hemorrhage above the skull that would be sufficient to have any merit at all. Our experts found and testified to a variety of placental changes. They testified to the fact that this child had no other organ damage, just the brain injury. Therefore, there had to have been enough adequate oxygenation to protect the other organs. Therefore, this had to be...
Isn't all of that the reason, moving to their second point, isn't all of that the reason that we don't let experts say, in addition to everything else I told you, these other 50 people who aren't here today agree with me?
Absolutely.
So in view of that, why isn't what happened in the 2 points they raise of bolstering, why isn't that reversible error?
First of all, the Philip Morris case specifically says that testifying that I never heard about that or that's not in the literature is not bolstering, because you're not citing to anything. You're saying I never heard of this. And Justice experts also agreed they never heard of this. There was no objection when their own experts said, yeah, I haven't seen this, I haven't experienced it. But by differential diagnosis, this is what I'm coming up with. They acknowledge there's nothing there.
But isn't that a significant difference in trial practice that it's proper to bring out on cross-examination of an expert? The opinion they're expressing, the doctor, isn't it true that there's no journal that is giving any credence to this? That's proper cross-examination versus improper direct examination.
The Philip Morris case specifically says it is appropriate direct examination. And having said that, our expert was wide open if Duss wanted to say, well, what about the Journal of XYZ or the Journal of ABC? This says thus and so. It certainly opened the door to them bringing out whatever they thought might have been some authoritative text, or some text, even if the doctor didn't agree that it was authoritative. They didn't. There's no error there. And in terms of our other expert mentioning a statistical analysis, we cited several cases, 2 of which I believe were cited in supplemental authority some time back. I'll call it Houghton, H-O-U-G-H-T-O-N case, it may be Houghton, and the Closter case.
To follow up on
Yes.
what Weatherall was talking about, it was not just, you gave a narrow response. Was there not also a reference to an NIH study?
The NIH was the statistical compilation of statistical study. Yes, that was used by a different expert. We had 2 experts. One, Dr. Thorpe, said, I've never heard of this. The other expert, Dr. Schwartz, referenced a statistical compilation by the NIH.
And that was referenced by a chart?
Yes.
And that was on direct examination?
Yes.
And that was in contravention to what the judge had ruled in the motion limine concerning the bolstering argument?
I believe that's correct.
And why would that not be inappropriate bolstering?
Well, we cited 2 cases in supplemental authority that both say that use of a government study is not bolstering. That is, particularly something like this that would be a statistical analysis. The Houghton case talks about crash test data, and the Closter case talks about climate data and compilations, that's not considered bolstering. Bolstering usually is a situation where someone wants to say, really, the standard of care type issues. The ACOG guidelines say an obstetrician should always do X. The XYZ guidelines or Jones on surgery says that you always do X during a certain procedure or you never do that. That's when I think it's the classical issue of bolstering is when you're talking about standard of care. Now, I'm not saying that you couldn't have a bolstering on causation, but we're not using these statistics other than as a background. And the cases that we cited say, even if for some reason experts can routinely rely on something that may not in itself be admissible, and they can talk about those things as the basis for their opinions.
What didn't the experts say, based upon foundation? This is my opinion, and my opinion is consistent with this NIH study.
I don't think he was quite as bold as that, but yes, in essence, that is what he was saying.
No question he can give his opinion testimony as an expert if the proper foundation is laid, correct?
Yes, correct.
But then you bridge over to, my opinion is consistent with, and then he references an NIH study with the chart. That's not bolstering?
I don't think so. Again, it's statistics. It's not how you're supposed to do something. It's statistics saying X number of babies have brain damage because of this reason, X number of babies have brain damage because of that reason, and it went down through a series of things, all of which were part of everybody's differential diagnosis on what are the reasons for certain types of brain damage. And this particular issue was not brought up in the plaintiff's motion for new trial. The only thing that was raised was the issue of their experts, their standard of care expert not being able to give certain causation opinions.
Well, I guess you're moving to a preservation type argument. Why is that? Would that be necessary? They made an objection. It was overruled. The jury heard the evidence. Is your argument that they had to re-raise it in a motion for new trial?
I think so. I think so. I've certainly in my practice, I've not seen anyone raise an issue on appeal that wasn't part of their post-trial motions. You're giving the judge, the trial court, a last opportunity to make the appropriate, from your side of the position, the losing party's position, to correct the claim of error.
But hasn't the legislature even gone the other way and essentially said once you get a definitive ruling, I guess even a pretrial ruling, you have that issue preserved?
I think the case law is perhaps not as crystal clear as it could be. Certainly, we cited several cases that said a bare bones motion for new trial does not preserve issues for appeal. So we would suggest that there was no preservation, although I readily acknowledge that they did raise the issue at the time the expert testified.
Let me ask you just another question. You were arguing a few cases on the merits of that issue. They weren't cited in your brief. Was there supplemental authority?
Yes, we did a notice of supplemental authority of both the Houghton case and the Closser case, and I don't, as I stand here, have on June 20th is the date that we did a notice of supplemental authority of those two decisions. It's Closser, K-L-O-S-T-E-R versus Rents. It's 733 South 2nd, 1102. That's a 3rd District case from 1999. And Houghton is H-O-U-G-H-T-O-N versus Bond. That's a 1st District case from 1996, found at 682 South 2nd, 574. Those cases, one of them is talking about using crash test data for the basis of opinions, and the other talks about using national climate data and saying that use of government studies is appropriate and is not considered bolstering. This was an NIH study. That's a government study. We believe that's not bolstering.
So if this had been a privately sponsored study, it would have been bolstering?
We don't have those facts.
I get that. I understand that. But
I think it...
I mean, really, is the line between bolstering and not bolstering in this instance simply the fact that this was an NIH study as opposed to a privately sponsored one?
I wouldn't want to draw the line that fine, and I don't know that the cases specifically have talked about government studies. I don't recall seeing any case talking about private compilations of statistics, but we do fall within the decisions that have permitted an expert to cite to government statistics. And again, the other side would have been, Justice Counsel or experts could have said, wait a minute, these statistics, you can pull different numbers from them. There was no cross-examination on these statistics and whether or not this was an appropriate analysis of the statistics. I see that my time is up. There's no further questions. We would respectfully request the court to affirm the final judgment in this matter. Thank you.
May I please the court? The error was preserved. As you recognize, Judge Weatherall, we did timely object with a specific legal objection. There was no requirement that we move for a new trial at that point once the objection was overruled. And in fact, frankly, we weren't even required to file a motion for a new trial directed to the issue of Dr. Schifrin, because that had also been preserved through an objection and proffer at trial. The cases that were cited in the supplemental authority are distinguishable. If you read those cases, I think to draw the conclusion that you can bolster with governmental data is not supported by those cases. In the Houghton case, there was no objection made to the use of the governmental data during the proffer, and it was more an instance of an expert relying on perhaps data that would have been inadmissible otherwise. Likewise, in the Kloster case, the data was used as a beginning point for the analysis, and the error was found to be harmless in that instance. Here, as the Supreme Court's recognized in the Lim case, it's not simply that. May I conclude? There are examples when an expert can rely on inadmissible data, but there are limitations to that, and one limitation is in the rules of evidence where you can't use an improper, inadmissible hearsay to bolster the opinion of your expert that has already been formed. As one final point, I would point out that our expert, Dr. Schifrin, had been retained by the FDA to study the relationship between vacuums and ischemic stroke. So to assert that our experts had never heard of this theory is contradicted by the record. For these reasons, we'd ask the court to reverse the judgment. Thank you.